What was the question?
The question is, did your May 29th press conference have anything to do with the fact that the previous day the judge threatened to hold your prosecutors in contempt for misrepresenting evidence?
No.
You know, the fundamental problem is, as I said, we've got to take your word, your team faithfully, accurately, impartially, and completely described all of the underlying evidence in the Mueller report, and we're finding more and more instances where this just isn't the case. And it's starting to look like, you know, having desperately tried and failed to make a legal case against the president, you made a political case instead. You put it in a paper sack, lit it on fire, dropped it on our porch, rang the doorbell, and ran.
I don't think you reviewed a report that is as thorough, as fair, as consistent as the report that we have in front of us.
Then why is contradictory
Time of the gentleman has expired. The gentleman from Maryland is recognized.
Director. And we recognize you're listening to Robert Mueller coverage on KIDO Talk Radio. We'll have this until Mr. Mueller is done testifying. Back to the coverage, KIDO Talk Radio.
With law enforcement, either by persuading them or intimidating them. Witness tampering is a felony punishable by 20 years in prison. You found evidence that the president engaged in efforts, and I quote, to encourage witnesses not to cooperate with the investigation. Is that right?
That's correct. Do you have a citation?
I'm page 7 on volume 2.
Thank you.
Now, one of these witnesses was Michael Cohen, the president's personal lawyer, who ultimately pled guilty to campaign violations based on secret hush money payments to two women the president knew, and also to lying to Congress about the hoped-for $1 billion Trump Tower deal. After the FBI searched Cohen's home, the president called him up personally, he said, to check in and told him to, quote, hang in there and stay strong. Is that right? Do you remember finding that?
If it's in the report as stated, yes, it is right.
Yes. Also in the report, actually, are a series of calls made by other friends of the president. One reached out to say he was with the boss in Mar-a-Lago, and the president said, he loves you. His name is redacted. Another redacted friend called to say, the boss loves you. And a third redacted friend called to say, everyone knows the boss has your back. Do you remember finding that sequence of calls?
Generally, yes.
When the news, and in fact, Cohen said that following the receipt of these messages, I'm quoting here, page 147 of volume 2, he believed he had the support of the White House if he continued to toe the party line, and he determined to stay on message and be part of the team. That's at page 147. Do you remember generally finding that?
Generally, yes.
Well, Robert Costello, a lawyer close to the president's legal team, emailed Cohen to say, quote, you are loved, they are in our corner, sleep well tonight, and you have friends in high places. And that's up on the screen, page 147. You remember reporting that. Okay. Now, when the news first that Cohen had arranged payoffs to Stormy Daniels, Cohen faithfully stuck to this party line. He said that publicly that neither the Trump Organization nor the Trump campaign was a party to the transaction, and neither reimbursed him. Trump's personal attorney at that point quickly texted Cohen to say, quote, client says thank you for what you do. Mr. Mueller, who is the capital C client thanking Cohen for what he does?
I can't speak to that.
Okay, the assumption in the context suggests very strongly it's President Trump.
I can't speak to that.
Okay. Cohen later broke and pled guilty to campaign finance offenses and admitted fully they were made, quote, at the direction of candidate Trump. Do you remember that?
Yes.
After Cohen's guilty plea, the president suddenly changed his tune towards Mr. Cohen, didn't he?
I would say I rely on what's in the report.
Well, he made the suggestion that Cohen family members had committed crimes. He targeted, for example, Cohen's father-in-law and repeatedly suggested that he was guilty of committing crimes, right?
Generally accurate.
Okay. On page 154, you give a powerful summary of these changing dynamics. And you said, I'm happy to have you read it, but I'm happy to do it if not.
I have it in front of me. Thank you.
Would you like to read it?
I would.
Can you read it out loud to everybody?
I would be happy to have you read it out.
Okay, very. We'll read it at the same time. The evidence concerning this sequence of events could support an inference that the president used inducements in the form of positive messages in an effort to get Cohen not to cooperate, and then turned to attacks and intimidation to deter the provision of information or to undermine Cohen's credibility once Cohen began cooperating.
I believe that's accurate.
Okay, and in my view, if anyone else in America engaged in these actions, they would have been charged with witness tampering. We must enforce the principle in Congress that you emphasize so well in the very last sentence of your report, which is that in America, no person is so high as to be above the law. I yield back, Mr. Chairman.
And you're listening to radio. Now the Republicans. You ever notice the Republicans seem to get short time and the Democrats go on and on and on. Back to the testimony on KIDO Talk Radio.
Indict the president is because of the OLC opinion. And you answered that is correct. But that is not what you said in the report, and it's not what you told Attorney General Barr. And in fact, in a joint statement that you released on May 29th, after your press conference, your office issued a joint statement with the Department of Justice that said, the Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying that but for the OLC opinion, he would have found the president obstructed justice. The special counsel's report in his statement today made clear that the office concluded it would not reach a determination one way or the other whether the president committed a crime. There is no conflict between these statements. So, Mr. Miller, do you stand by your joint statement with DOJ that you issued on May 29th as you sit here today?
I would have to look at it more closely before I said I agree with it.
Well, my conclusion is that what you told Mr. Liu really contradicts what you said in the report, and specifically what you said apparently repeatedly to Attorney General Barr, and then you issued a joint statement on May 29th saying that the Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying but for the OLC report that we would have found the president obstructed justice. So I just say there's a conflict. I do have some more questions. Mr. Mueller, there's been a lot of talk today about firing the special counsel and curtailing the investigation. Were you ever fired, Mr. Mueller, from the special?
What?
Were you ever fired as special counsel, Mr. Mueller?
No.
No. Were you allowed to complete your investigation unencumbered?
Yes.
And in fact, you resigned as special counsel when you closed up the office in late May 2019. Is that correct?
That's correct.
Thank you. Mr. Mueller, on April 18th, the Attorney General held a press conference in conjunction with the public release of your report. Did Attorney General Barr say anything inaccurate either in his press conference or his March 24th letter to Congress summarizing the principal conclusions of your report?
Well, what you are not mentioning is a letter we sent on March 27th to Mr. Barr that raised some issues. And that letter speaks for itself.
But then I don't see how you that could be, since A.G. Barr's letter detailed the principal conclusions of your report, and you have said before that there wasn't anything inaccurate. In fact, you had this joint statement. But let me go on to another question. Mr. Mueller, rather than purely relying on the evidence provided by witnesses and documents, I think you relied a lot on media. I'd like to know how many times you cited the Washington Post in your report.
How many times I what?
Cited the Washington Post in your report.
I do not have knowledge of that figure, but that's it. I don't have knowledge of that figure.
I counted about 60 times. How many times did you cite the New York Times? I counted.
Again, I have no idea.
I counted about 75 times. How many times did you cite Fox News?
As with the other two, I have no idea.
About 25 times. I've got to say, it looks like Volume 2 is mostly regurgitated press stories. Honestly, there's almost nothing in Volume 2 that I couldn't already hear or know simply by having a $50 cable news subscription. However, your investigation cost the American taxpayers $25 million. Mr. Mueller, you cited media reports nearly 200 times in your report. Then in a footnote, a small footnote, number 7, page 15 of volume 2 of your report, you wrote, I quote, "This section summarizes and cites various news stories not for the truth of the information contained in the stories, but rather to place candidate Trump's response to those stories in context. Since nobody but lawyers reads footnotes, are you concerned that the American public took the embedded news stories?"
Time of the gentlelady has expired. The gentlelady from Washington.
Can Mr. Mueller?
And there you have it. We will continue on and we'll take your phone calls. Kevin Miller, KIDO Talk Radio. Back to the Mueller hearings. Contentious on Capitol Hill.
Thank you. Director Mueller, let's turn to the 5th of the obstruction episodes in your report, and that is the evidence of whether President Trump engaged in witness tampering with Trump campaign chairman Paul Manafort, whose foreign ties were critical to your investigation into Russia's interference in our elections. And this starts at volume 2, page 123. Your office got indictments against Manafort and Trump deputy campaign manager Rick Gates in 2 different jurisdictions, correct?
Correct.
And your office found that after a grand jury indicted them, Manafort told Gates not to plead guilty to any charges because, quote, he had talked to the president's personal counsel and they were going to take care of us. Is that correct?
That's accurate.
And according to your report, one day after Manafort's conviction on 8 felony charges, quote, the president said that flipping was not fair and almost ought to be outlawed. Is that correct?
I'm aware of that.
In this context, Director Mueller, what does it mean to flip?
Have somebody cooperate in a criminal investigation.
And how essential is that cooperation to any efforts to combat crime?
Well, I'm not going to go beyond that, characterizing that
Thank
effort.
you. In your report, you concluded that President Trump and his personal counsel, Rudy Giuliani, quote, made repeated statements suggesting that a pardon was a possibility for Manafort, while also making it clear that the president did not want Manafort to flip and cooperate with the government, end quote. Is that correct?
Correct.
And as you stated earlier, witness tampering can be shown where someone with an improper motive encourages another person not to cooperate with law enforcement. Is that correct?
Correct.
Now, on page 123 of volume 2, you also discuss the president's motive, and you say that as court proceedings move forward against Manafort, President Trump, quote, discussed with aides whether and in what way Manafort might be cooperating and whether Manafort knew any information that would be harmful to the president, end quote. Is that correct?
And that was a quote from?
From page 123, volume 2.
I have it. Thank you. Yes.
And when someone tries to stop another person from working with law enforcement and they do it because they're worried about what that person will say, it seems clear from what you wrote that this is a classic definition of witness tampering. Now, Mr. Manafort did eventually decide to cooperate with your office, and he entered into a plea agreement, but then he broke that agreement. Can you describe what he did that caused you to tell the court that the agreement was off?
I'd refer you to the court proceedings on that issue.
So on page 127 of volume 2, you told the court that Mr. Manafort lied about a number of matters that were material to the investigation, and you said that the Manafort's lawyers also, quote, regularly briefed the president's lawyers on topics discussed and the information that Manafort had provided in interviews with the special counsel's office. Does that sound right?
And the source of that is?
That's page 127, volume 2. That's a direct quote.
If it's from the report, yes, I'd support it.
And 2 days after you told the court that Manafort broke his plea agreement by lying repeatedly, did President Trump tell the press that Mr. Manafort was, quote, very brave because he did not flip? This is page 128 of volume 2.
If it's in the report, I support it as it is set forth.
Thank you. Director Mueller, in your report, you make a very serious conclusion about the evidence regarding the president's involvement with the Manafort criminal proceedings. Let me read to you from your report. Evidence concerning the president's conduct toward Manafort indicates that the president intended to encourage Manafort to not cooperate with the government. It is clear that the president both publicly and privately discouraged Mr. Manafort's cooperation or flipping while also dangling the promise of a pardon if he stayed loyal and did not share what he knew about the president. Anyone else who did these things would be prosecuted for them. We must ensure that no one is above the law. And I thank you for being here, Director Mueller. Yield back.
Gentleman from Pennsylvania.
And remember, you're listening to Mueller coverage right here on KIDO Talk Radio, 107.5 FM, 580 AM. Don't forget Glenn Beck, Sean Hannity, Lars Larson, and Dave Ramsey will have much, much more. Back to Robert Mueller talking to the Republicans.
I'm sorry.
Are you familiar with the independent counsel statute?
Are you talking about the one that we're operating under now or a previous?
No, under which Ken Starr was appointed?
I am not that familiar with that, but I'd be happy to take your question.
Well, the Clinton administration allowed the independent counsel statute to expire after Ken Starr's investigation. The final report requirement was a major reason why the statute was allowed to expire. Even President Clinton's AG, Janet Reno, expressed concerns about the final report requirement. And I'll quote AG Reno. She said, "On one hand, the American people have an interest in knowing the outcome of an investigation of their highest officials. On the other hand, the report requirement cuts against many of the most basic traditions and practices of American law enforcement. Under our system, we presume innocence and we value privacy. We believe that information obtained during a criminal investigation should, in most cases, be made public only if there is an indictment and prosecution, not in a lengthy and detailed report filed after a decision has been made not to prosecute. The final report provides a forum for unfairly airing a target's dirty laundry, and it also creates yet another incentive for an independent counsel to over-investigate in order to justify her tenure and to avoid criticism that the independent counsel may have left a stone unturned." Again, Mr. Mueller, those are AG Reno's words. Didn't you do exactly what AG Reno feared? Didn't you publish a lengthy report unfairly airing the target's dirty laundry without recommending charges?
I disagree with that.
Okay. Did any of your witnesses have the chance to be cross-examined?
Can I just finish my answer on that?
Quickly.
I operate under the current statute, not the original statute, so I am most familiar with the current statute, not the older statute.
Did any of the witnesses have a chance to be cross-examined?
Did any of the witnesses in our investigation?
Yes.
I'm not going to answer that.
Okay. Did you allow the people mentioned in your report to challenge how they were characterized?
I'm not going to get into
into that. Given that AG Barr stated multiple times during his confirmation hearing that he would make as much of your report public as possible, did you write your report knowing that it would likely be shared with the public?
No.
Did knowing that the report could and likely would be made public, did that alter the contents which you included?
I can't speak to that.
Despite the expectations that your report would be released to the public, you left out significant exculpatory evidence. In other words, evidence favorable to the president, correct?
Well, I actually would disagree with you. I think we strove to put into the report exculpatory evidence as well.
I'm pretty sure Tom got into that with you, where you said there was evidence you left out.
Well, you make a choice as to what goes into
Isn't it true, Mr. Mueller, isn't it true that on page 1 of volume 2, you state, when you're quoting the statute, that you had an obligation to either prosecute or not prosecute?
Well, generally that is the case.
Right.
Although most cases are not done in the context of the president.
And in this case, you made a decision not to prosecute, correct?
No, we made a decision not to decide whether to prosecute or not.
So essentially what your report did was everything that AG Reno warned against.
I can't agree with that characterization.
Okay. Well, what you did is you compiled nearly 450 pages of the very worst information you gathered against the target of your investigation, who happens to be the President of the United States. And you did this knowing that you were not going to recommend charges and that the report would be made public.
Not true.
Mr. Mueller, as a former officer in the United States JAG Corps, I prosecuted nearly 100 terrorists in a Baghdad courtroom. I cross-examined the Butcher of Fallujah in defense of our Navy SEALs. As a civilian, I was elected a magisterial district judge in Pennsylvania, so I'm very well versed in the American legal system. The drafting and the publication of some of the information in this report without an indictment, without prosecution, frankly flies in the face of American justice. And I find those facts, this entire process, un-American. I yield the remainder of my time to my colleague, Jim Jordan.
Director Mueller, the third FISA renewal happens a month after you're named special counsel. What role did your office play in the third FISA renewal of Carter Page?
I'm not going to talk to that.
Time of the gentleman has expired. The gentlelady from Florida.
You're listening to KIDO Talk Radio. Mo Mueller next with Kevin Miller. Keep it here. Kevin Miller in the morning, KIDO Talk Radio. Our coverage continues. Now back to Bob Mueller, and looks like the lib's just about done, and we'll hear from the Republicans on KIDO Talk Radio.
Thank you, Mr. Chairman. Mr. Mueller, we've heard a lot about what you're not going to talk about today, so let's talk about something that you should be able to talk about, the law itself, the underlying obstruction statute, and your creative legal analysis of the statutes in Volume 2, particularly your interpretation of 18 U.S.C. 1512C. Section 1512C is an obstruction of justice statute created as part of auditing and financial regulations for public companies, and as you write on page 164 of Volume 2, this provision was added as a floor amendment in the Senate and explained as closing a certain loophole with respect to document shredding. And to read the statute, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under the statute or imprisoned not more than 20 years or both. Your analysis and application of the statute proposes to give Clause C2 a much broader interpretation than commonly used. First, your analysis proposes to read Clause C2 in isolation, reading it as a freestanding, all-encompassing provision prohibiting any act influencing a proceeding if done with an improper motive. And second, your analysis of the statute to apply this proposes to apply this sweeping prohibition to lawful acts taken by public officials exercising their discretionary powers if those acts influence a proceeding. So, Mr. Mueller, I'd ask you, in analyzing the obstruction, you state that you recognize that the Department of Justice and the courts have not definitively resolved these issues, correct?
Correct.
You'd agree that not everyone in the Justice Department agreed with your legal theory of the obstruction of justice statutes, correct?
I'm not going to be involved in the discussion on that at this juncture.
In fact, the Attorney General himself disagrees with your interpretation of the law, correct?
I leave that to the Attorney General to identify.
And you would agree that prosecutors sometimes incorrectly apply the law, correct?
I would have to agree with that one. Yes.
And members of your legal team, in fact, have had convictions overturned because they were based on an incorrect legal theory, correct?
I don't know to what you advert. We've all who spent time in the trenches trying cases have not won every one of those cases.
Well, let me ask you about one in particular. One of your top prosecutors, Andrew Weissman, obtained a conviction against auditing firm Arthur Anderson, lower court, which was subsequently overturned in a unanimous Supreme Court decision that rejected the legal theory advanced by Weissman, correct?
Well, I'm not going to get into delve into
Let me read from that. Maybe it'll
May I just finish? May I just finish my answer to say that I'm not going to get involved in a discussion on that. I will refer you to that citation that you gave me at the outset for the lengthy discussion on just what you're talking about, and to the extent that I have anything to say about it, it is what we have already put into the report on that
issue.
I
am reading from your report when discussing this section, and I'll read from the decision of the Supreme Court unanimously reversing Mr. Weissman when he said, indeed, it's striking how little culpability the instructions required. For example, the jury was told that even if petitioner honestly and sincerely believed his conduct was lawful, the jury could convict. The instructions also diluted the meaning of corruptly such that it covered innocent conduct.
Let me just say, put a word for...
Let me move on. I have limited time. Your report takes the broadest possible reading of this provision and applying it to the president's official acts, and I'm concerned about the implications of your theory for over-criminalizing conduct by public officials and private citizens alike. So to emphasize how broad your theory of liability is, I want to ask you about a few examples. On October 11th, 2015, during the FBI investigation into Hillary Clinton's use of a private email server, President Obama said, "I don't think it posed a national security problem." And he later said, "I can tell you that this is not a situation in which America's national security was endangered." Assuming for a moment that his comments did influence the investigation, couldn't President Obama be charged under your interpretation with obstruction of justice?
Well, again, I refer you to the report, but let me say with Andrew Weissman, who is one of the more talented attorneys that we have and have on board.
Okay, well, I'll take that
over a period of time. He has run a number of units.
I have very limited time. In August 2015, a very senior DOJ official called FBI Deputy Director Andrew McCabe, expressing concern that FBI agents were still openly pursuing the Clinton Foundation probe. The DOJ official was apparently very pissed off, quote unquote. McCabe questioned this official, asking, "Are you telling me I need to shut down a validly predicated investigation?" To which the official replied, "Of course not." This seems to be a clear example of somebody within the executive branch attempting to influence an FBI investigation. So under your theory, couldn't that person be charged with obstruction as long as a prosecutor could come up with a potentially corrupt motive?
I refer you to our lengthy dissertation on exactly those issues that appears at the end of the report.
Mr. Mueller, I'd argue that it says above the Supreme Court, equal justice under law.
Time of the gentleman has expired.
Not stretched.
Our intent was to conclude this hearing in 3 hours. Given the break, that would bring us to approximately 11:40. With Director Mueller's indulgence, we will be asking our remaining Democratic members to voluntarily limit their time below the 5 minutes so that we can complete our work as close to that time frame as possible. And I recognize the gentlelady from Pennsylvania.
And you're listening to KIDO Talk Radio. The Mueller hearings continuing on KIDO Talk Radio.
Statements regarding advanced knowledge of the WikiLeaks dumps. So the president refused to sit down with your investigators for an in-person interview, correct?
Correct.
So the only answers we have to questions from the president are contained in Appendix C to your report.
That's correct.
Okay, so looking at Appendix C on page 5, you asked the president over a dozen questions about whether he had knowledge that WikiLeaks possessed or might possess the emails that were stolen by the Russians.
I apologize.
Sure.
Can you start it again?
Okay, sure. So we're looking at Appendix C.
Right.
And at Appendix C, page 5, you asked the president about a dozen questions about whether he had knowledge that WikiLeaks possessed the stolen emails that might be released in a way helpful to his campaign or harmful to the Clinton campaign. Is that correct? You asked those questions? Okay. In February of this year, Mr. Trump's personal attorney, Michael Cohen, testified to Congress under oath that, quote, Mr. Trump knew from Roger Stone in advance about the WikiLeaks drop of emails, end quote. That's a matter of public record, isn't it?
Well, are you referring to the report or some other public record?
This was testimony before Congress by Mr. Cohen. Do you know if he told you?
I'm not familiar with it, explicitly familiar with what he testified to before Congress.
Okay. Let's look at an event described on page 18 of volume 2 of your report. Now, and we're going to put it up in a slide, I think. According to Deputy Campaign Manager Rick Gates, in the summer of 2016, he and candidate Trump were on the way to an airport shortly after WikiLeaks released its first set of stolen emails. And Gates told your investigators that candidate Trump was on a phone call, and when the call ended, Trump told Gates that more releases of damaging information would be coming, end quote. Do you recall that from the report?
If it's in the report, I support it.
Okay, and that's on page 18 of volume 2. Now, on page 77 of volume 2, your report also stated, quote, in addition, some witnesses said that Trump privately sought information about future WikiLeaks releases, end quote. Is that correct?
Correct.
Okay. Now, in Appendix C, where the president did answer some written questions, he said, quote, I do not recall discussing WikiLeaks with him, nor do I recall being aware of Mr. Stone having discussed WikiLeaks with individuals associated with my campaign, end quote. Is that correct?
If it's from the report, it is correct.
Okay. So is it fair to say the president denied ever discussing WikiLeaks with Mr. Stone and denied being aware that anyone associated with his campaign discussed WikiLeaks with Stone?
I'm sorry, could you repeat that one?
Is it fair then that the president denied knowledge of himself or anyone else discussing WikiLeaks dumps with Mr. Stone?
Yes.
Okay. And with that, I would yield back.
Thank you, ma'am.
And we'll have the Republicans speaking. You're listening to KIDO Talk Radio. Robert Mueller testifying before the Judiciary Committee.
Interview for the FBI director job one day before you were appointed as special counsel?
My understanding, I was not applying for the job. I was asked to give my input on what it would take to do the job, which triggered the interview you're talking about.
So you don't recall on May 16, 2017, that you interviewed with the president regarding the FBI director job?
I interviewed with the president, and
regarding the FBI director job?
It was about the job and not about me applying for the job.
So your statement here today is that you didn't interview to apply for the FBI director job?
That's correct.
So Did you tell the vice president that the FBI director position would be the one job that you would come back for?
Don't recall that one.
You don't recall that?
No.
Okay. Given your 22 months of investigation, tens of millions of dollars spent, and millions of documents reviewed, did you obtain any evidence at all that any American voter changed their vote as a result of Russians' election interference?
I'm not going to speak to that.
You can't speak to that? After 22 months of investigation, there's not any evidence in that document before us that any voter changed their vote because of their interference, and I'm asking you based on all of the documents that you reviewed.
That was outside our purview.
Russian meddling was outside your purview?
But the impact of that meddling was undertaken by other agencies.
Okay. You stated in your opening statement that you would not get into the details of the Steele dossier. However, multiple times in Volume 2 on page 23, 27, and 28, you mentioned the unverified allegations. How long did it take you to reach the conclusion that it was unverified?
I'm not going to speak to that.
It's actually in your report multiple times that it's unverified, and you're telling me that you're not willing to tell us how you came to the conclusion that it was unverified.
True.
When did you become aware that the unverified Steele dossier was included in the FISA application to spy on Carter Page?
I'm sorry. What was the question?
When did you become aware that the unverified Steele dossier was included in the FISA application to spy on Carter Page?
I'm not going to speak to that.
Your team interviewed Christopher Steele. Is that correct?
Not going to get into that.
You can't tell this committee as to whether or not you interviewed Christopher Steele in a 22-month investigation with 18 lawyers.
As I said at the outset, that is one of the investigations that is being handled by others in the Department of Justice.
Yeah, but you're here testifying about this investigation today. And I am asking you directly, did any members of your team or did you interview Christopher Steele in the course of your investigation?
And I am not going to answer that question, sir.
You had 2 years to investigate. Not once did you consider it worthy to investigate how an unverified document that was paid for by a political opponent was used to obtain a warrant to spy on the opposition political campaign. Did you do any investigation in that whatsoever?
I do not accept your characterization of what occurred.
What would be your characterization?
I'm not going to speak any more to it.
So you can't speak any more to it, but you're not going to agree with my characterization. Is that correct?
Yes.
The FISA application makes reference to Source One, who was Christopher Steele, the author of the Steele dossier. The FISA application says nothing Sources One's reason for conducting the research into candidate one's ties to Russia, based on Sources One previous reporting history with FBI, whereby Source One provided reliable information to the FBI. The FBI believes Source One's reporting herein to be credible. Do you believe the FBI's representation that Source One's reporting was credible to be accurate?
I'm not going to answer that.
So you're not going to respond to any of the questions regarding Christopher Steele or your interviews with them?
Well, as I said at the outset this morning, that was one of the investigations that I could not speak to.
Well, I don't understand how, if you interviewed an individual on the purview of this investigation that you're testifying to us today, that you've closed that investigation, how that's not within your purview to tell us about that investigation and who you interviewed.
I have nothing to add.
Okay, well, I can guarantee that the American people want to know. And I'm very hopeful and glad that AG Barr is looking into this and the Inspector General is looking into this, because you're unwilling to answer the questions of the American people as it relates to the very basis of this investigation into the president and the very basis of this individual who you did interview. You're just refusing to answer those questions. Can't the president fire the FBI director at any time without reason under Article 1 of the Constitution?
Yes.
Article 2?
Yes.
That's correct. Can't he also fire you as special counsel at any time without any reason?
I believe that to be the case.
Under Article 2?
Well, hold on just a second. You said without any reason. I know that special counsel can be fired, but I'm not certain it extends to for whatever reason is given.
Well, and you've testified that you weren't fired. You were able to complete your investigation in full. Is that correct?
I'm not going to add to what I've stated before.
My time's expired.
And what we're going to do here on KIDO Talk Radio, we're going to hear from the little libs, but we're going to take a break, rehash, reload, and then hear what you have to say. Kevin Miller, KIDO Talk Radio. Back to the hearings, Kevin Miller, KIDO Talk Radio.
At least partially because you were worried about concerned about preserving the appearance of independence with the special counsel's investigation. Do you agree with that statement?
The statement was by whom?
Peter Strzok at this hearing.
And I am not familiar with that.
Did you fire him because you were worried about the appearance of independence of the investigation?
No, he was transferred as a result of instances involving texts.
Do you agree that your office did not only have an obligation to operate with independence, but to operate with the appearance of independence as well?
Absolutely. We strove to do that over the 2 years.
Andrew Weissman?
Part of that was making certain that...
Andrew Weissman's one of your top attorneys?
Yes.
Did Weissman have a role in selecting other members of your team?
He had some role, but not a major role.
Andrew Weissman attended Hillary Clinton's election night party. Did you know that before or after he came onto the team?
Don't know when I found that out.
On January 30th, 2017, Weissman wrote an email to Deputy Attorney General Yates stating, "I am so proud and in awe," regarding her disobeying a direct order from the president. Did Weissman disclose that email to you before he joined the team?
Yeah, I'm not going to talk about that.
Is that not a conflict of interest?
I'm not going to talk about that.
Are you aware that Ms. Jeannie Rhee represented Hillary Clinton in litigation regarding personal emails originating from Clinton's time as Secretary of State?
Yes.
Did you know that before she came on the team?
No.
Aaron Zelbley, the guy sitting next to you, represented Justin Cooper, a Clinton aide who destroyed one of Clinton's mobile devices. And you must be aware by now that 6 of your lawyers donated $12,000 directly to Hillary Clinton. I'm not even talking about the $49,000 they donated to other Democrats, just the donations to the opponent who was the target of your investigation.
Can I speak for a second to the hiring practices?
Sure.
We strove to hire those individuals that could do the job. I've been in this business for almost 25 years, and in those 25 years, I have not had occasion once to ask somebody about their political affiliation. It is not done. What I care about is the capability of the individual to do the job and do the job quickly and seriously and with integrity.
But that's what I'm saying, Mr. Mueller. This isn't just about you being able to vouch for your team. This is about knowing that the day you accepted this role, you had to be aware no matter what this report concluded, half of the country was going to be skeptical of your team's findings. And that's why we have recusal laws that define bias and perceive bias for this very reason. 28 United States Code 528 specifically lists not just political conflict of interest, but the appearance of political conflict of interest. It's just simply not enough that you vouch for your team. The interested justice demand that no perceived bias exists. I can't imagine a single prosecutor or judge that I have ever appeared in front of would be comfortable with these circumstances where over half of the prosecutorial team had a direct relationship to the opponent of the person being investigated.
Let me one other fact that I put on the table, and that is we hired 19 lawyers over the period of time. Of those 19 lawyers, 14 of them were transferred from elsewhere in the Department of Justice. Only 5 came from outside.
And so half of them had a direct relationship, political or personal, with the opponent of the person you were investigating. And that's my point. I wonder if not a single word in this entire report was changed, but rather the only difference was we switched Hillary Clinton and President Trump. If Peter Strzok had texted those terrible things about Hillary Clinton instead of President Trump, if a team of lawyers worked for, donated thousands of dollars to, and went to Trump's parties instead of Clinton's, I don't think we'd be here trying to prop up an obstruction allegation. My colleagues would have spent the last 4 months accusing your team of being bought and paid for by the Trump campaign, and we couldn't trust a single word of this report. They would still be accusing the president of conspiracy with Russia, and they would be accusing your team of aiding and abetting in that, with that conspiracy. And with that, I yield back.
Gentleman yields back. The gentleman from Colorado.
Director Mueller, thank you for your service to our country. I'd like to talk to you about one of the other incidents of obstruction, and that's the evidence in your report showing the president directing his son and his communications director to issue a false public statement in June of 2017 about a meeting between his campaign and Russian individuals at Trump Tower in June of 2016. According to your report, Mr. Trump Jr. was the only Trump associate who participated in that meeting and who declined to be voluntarily interviewed by your office. Is that correct?
Yes.
Did Mr. Trump Jr. or his counsel ever communicate to your office any intent to invoke his Fifth Amendment right against self-incrimination?
I'm not going to answer that.
You did pose written questions to the president about his knowledge of the Trump Tower meeting. You also asked him about whether or not he had directed a false press statement. The president did not answer at all that question, correct?
I don't have it in front of me. I take your word.
I can represent to you that Appendix C, specifically C13, states as much. According to page 100 of Volume 2 of your report, your investigation found that Hope Hicks, the president's communications director, in June of 2017 was shown emails that set up the Trump Tower meeting, and she told your office that she was, quote, shocked by the emails because they looked, quote, really bad. True?
Do you have the citation?
Sure. It's page 100 of Volume 2. While you're flipping to that page, Director Mueller, I will also tell you that according to page 99 of Volume 2, those emails in question stated, according to your report, that the Crown Prosecutor of Russia had offered to provide the Trump campaign with some official documents and information that would incriminate Hillary and her dealings with Russia as part of Russia and its government's support for Mr. Trump. Trump Jr. responded, if it's what you say, I love it. And he, Kushner, and Manafort met with the Russian attorneys and several other Russian individuals at Trump Tower on June 9th, 2016, end quote, correct?
Generally accurate.
Isn't it true that Ms. Hicks told your office that she went multiple times to the president to, quote, urge him that they should be fully transparent about the June 9th meeting, end quote, but the president each time said no, correct?
Accurate.
And the reason was because of those emails, which the president, quote, believed would not leak, correct?
Well, I'm not certain how it's characterized, but generally correct.
Did the president direct Ms. Hicks to say, quote, only that Trump Jr. took a brief meeting and it was about Russian adoption, end quote, because Trump Jr.'s statement to the New York Times, quote, said too much, according to page 102 of Volume 2?
Okay.
Correct?
Let me just check one thing. Yes.
And according to Ms. Hicks, the president still directed her to say the meeting was only about Russian adoption, correct?
Yes.
Despite knowing that to be untrue. Thank you, Director Mueller. I yield back the balance of my own time.
Mr. Mueller.
And here we go. Another Republican. You're listening to KIDO Talk Radio, home of Sean Hannity and Glenn Beck.
You performed as most of us expected. You've stuck closely to your report, and you have declined to answer many of our questions on both sides. As the closer for the Republican side, I know you're glad to get to the close, I want to summarize the highlights of what we have heard and what we know. You spent 2 years and nearly $30 million taxpayer dollars and unlimited resources to prepare a nearly 450-page report, which you described today as very thorough. Millions of Americans today maintain genuine concerns about your work, in large part because of the infamous, widely publicized bias of your investigating team members, which we now know included 14 Democrats and 0 Republicans. Campaign finance reports later showed that team, excuse me, it's my time, that team of Democrat investigators you hired donated more than $60,000 to the Hillary Clinton campaign and other Democratic candidates. Your team also included Peter Strzok and Lisa Page, which have been discussed today, and they had the lurid text messages that confirmed they openly mocked and hated Donald Trump and his supporters, and they vowed to take him out. Mr. Ratcliffe asked you earlier this morning, quote, can you give me an example other than Donald Trump where the Justice Department determined that an investigated person was not exonerated because their innocence was not conclusively determined, unquote? You answered, I cannot. Sir, that is unprecedented. The president believed from the very beginning that you and your special counsel team had serious conflicts. This is stated in the report and acknowledged by everybody. And yet, President Trump cooperated fully with the investigation. He knew he had done nothing wrong, and he encouraged all witnesses to cooperate with the investigation and produced more than 1.4 million pages of information and allowed over 40 witnesses who were directly affiliated with the White House or his campaign. Your report acknowledges on page 61, volume 2, that a volume of evidence exists of the president telling many people privately, quote, the president was concerned about the impact of the Russian investigation on his ability to govern and to address important foreign relations issues and even matters of national security. And on page 174, volume 2, your report also acknowledges that the Supreme Court has held, quote, the president's removal powers are at their zenith with respect to principal officers, that is, officers who must be appointed by the president and who report to him directly. The president's exclusive and illimitable power of removal of those principal officers furthers the president's ability to ensure that the laws are faithfully executed, unquote. And that would even include the attorney general. Look, in spite of all of that, nothing ever happened to stop or impede your special counsel's investigation. Nobody was fired by the president, nothing was curtailed, and the investigation continued unencumbered for 22 long months. As you finally concluded in Volume 1, the evidence, quote, did not establish that the president was involved in an underlying crime related to Russian election interference, unquote. And the evidence, quote, did not establish that the president or those close to him were involved in any Russian conspiracies or had an unlawful relationship with any Russian official, unquote. Over those 22 long months that your investigation dragged along, the president became increasingly frustrated, as many of the American people did, with its effects on our country and his ability to govern. He vented about this to his lawyer and his close associates, and he even shared his frustrations, as we all know, on Twitter. But while the president's social media accounts might have influenced some in the media or the opinion of some of the American people, none of those audiences were targets or witnesses in your investigation. The president never affected anybody's testimony. He never demanded to end the investigation or demanded that you be terminated, and he never misled Congress, the DOJ, or the special counsel. Those, sir, are undisputed facts. There will be a lot of discussion, I predict today, and great frustration throughout the country about the fact that you wouldn't answer any questions here about the origins of this whole charade, which was the infamous Christopher Steele dossier, now proven to be totally bogus, even though it is listed and specifically referenced in your report. But as our hearing is concluding, we apparently will get no comment on that from you. Mr. Mueller, there's one primary reason why you were called here today and by the Democrat majority of our committee. Our colleagues on the other side of the aisle just want political cover. They desperately wanted you today to tell them they should impeach the president. But the one thing you have said very clearly today is that your report is complete and thorough, and you completely agree with and stand by its recommendations and all of its content. Is that right?
True.
Mr. Mueller, one last important question. Your report does not recommend impeachment, does it?
I'm not going to talk about recommendations.
It does not conclude that impeachment would be appropriate here, right?
I'm not going to talk about that issue.
That's one of the many things you wouldn't talk about today, but I think we can all draw our own conclusions. I do thank you for your service to the country, and I'm glad this charade will come to an end soon, and we can get back to the important business of this committee with its broad jurisdiction of so many important issues for the country. With that, I yield back.
You're listening to KIDO Talk Radio. And we continue on with our coverage. Let's go to the phones. Kevin Miller in the morning. Tea Party Bob joins us now. Good morning, Tea Party Bob.
Good morning, Mr. Miller. Great show this morning. Thanks for airing this. This is very important.
Thank you.
You know, this hearing's like eating day-old hacks for breakfast. It's stale, crusty, and should have been thrown out in the trash. There's nothing damning that is coming out in this hearing about the president that hasn't already been exposed. This is just another sideshow at the Democratic circus. There is no real basis for having this hearing in the first place. If there were anything of real importance in this hearing, it is that it showed the bias of the special prosecutor and his team of witch hunters who had nothing in mind from the beginning but to get Trump any way that they could. I do believe that there is a positive side to this hearing. That is that the hearing is going to bring forth the American public an opportunity to see the charade of angry Democrats and hand the Republicans a victory in both the House and the Senate, along with President Trump, for another 4 years. And I do believe A.G. Barr will do some proper investigations in the background of how this special counsel investigation started and why it started. From the beginning, I believe this whole witch hunt was perpetrated by the Democrats to protect the Clintons and the DNC from being exposed.
Well, I'll tell you, Mueller did not come across very well. He seemed befuddled and couldn't really read his own report.
He hasn't answered more than 60% of the questions for reasons that he says he can.
Well, and that you know, if you ever notice, he has trouble hearing, and I'm thinking, you know, look, you're a pretty spry guy, and you're pretty with it, but with all due respect, why they got Mueller here at his age, it does not look good for him.
Well, it kind of shows you why he should not have been in charge of this investigation in the first place, and the fact that he had a problem with Trump because of his FBI position.
Well, and you hear the congressman, and it's funny how helpful he is with the libs, but you hear the congressman, when they ask him a question that he doesn't want to answer, I'm not going to speak to that. And I think we've had enough of beyond my purview today.
Well, everything's been beyond his purview. In fact, this whole investigation should have been beyond his purview. He did a real shitty job on this whole thing. It never should have been perpetrated in the first place. There was no reason for it. And I just think it's another dog and pony show.
Now, remember, thankfully we dumped that, but you can't use that language on the Queen's airwaves.
You mean the pony show?
No, you can't use the swear words that you just used. Shame, shame, know your name.
Well, I'll tell you, there are a lot more words that I have for Mueller that I can't say on the air, but I can say in private.
Well,
the man deserves to basically be disbarred for what he did here.
Tea Party Bob, thank you for staying with us here on KIDO Talk Radio, the extended version of the Kevin Miller program. Of course, Glenn Beck and Sean Hannity and Lars will have much, much more, and then we'll hit it tomorrow as well. We appreciate you, brother.
Thank you, my friend. Have a good day.
Thank you. Kurt in Boise with Kevin Miller on KIDO Talk Radio. Hello, Kurt.
Good morning, Kevin. Hey, I just wanted to thank you for playing all this. I'm just glad that it's getting out there. But I totally agree with you. This guy, he just stumbles and stutters through the whole thing. I mean, I thought he would be a lot more articulate. I mean, it's almost I don't understand if he's so smart and so been doing this for so long, how he can't even talk without stuttering.
He didn't come across very well, and, he couldn't hear. He couldn't figure out the microphone. You're thinking, this guy's in charge of millions of dollars of investigations. He didn't show much competency in supervising his staff. He's either, the old saying, Kurt, he's either complicit or incompetent.
Exactly, brother. Well, don't forget it. I remember I've been listening to your show for a very long time, and you had a couple of really good guests on there that said that he's actually been in Clinton's pockets since Bill was president. So I think that's part of the deal here is that, he's getting old, but they also appointed him because he was in Clinton's pocket. So,
well, he's got to know what side his bread's buttered. Kurt, thank you for listening to KIDO Talk Radio, brother. We appreciate it.
I love you too, man. Bye.
Love you. All right. We love everybody, even the libs. God bless. Keep the faith. Glenn Beck is next. Kevin Miller, KIDO Talk Radio.